चलो આવું કરો ને આવો રાખો સાહેબ ચા કોફી લેશો હવે મને તો એવું કીધું તમે અંદર નહીં કહી શકો સાહેબ ચા કોફી નાસ્તો છે તમે હવે એને તો નહીં કહી શકો કે તમે મને પણ તને કહેવાય મને ખબર નહીં સાહેબ બોલાવશે મને ના કહેવાય
How are you? Fine. Good to see you. Arre, thank you, sir. Kakkar sahib, કેમ છો? How lovely to see you. કેમ છો તમે? મજામાં છો? હા જી. મજામાં છે.
Welcome you all on behalf of Justice P.D. Desai Memorial Lecture Committee and Praleen Public Charitable Trust to today's Memorial Lecture to be delivered by Honorable Mr. Justice Rohinton Nariman, Judge, Supreme Court of India.
Begin this auspicious occasion, may I request Shri Amar Bhatt, Advocate, to offer prayer. Amar Bhai has selected one of the masterpieces, Shabad Sadhana Kije, from the treasure of Sant Kabir's creations, where Kabir has tried to explain power of words.
संयुक्तं नित्यं ध्यायन्ति योगिनः कामदं मोक्षदं चैव ओंकाराय नमो नमः ओंकाराय नमो नमः साधो साधो शब्द साधना कीजय साधो शब्द साधना कीजय जेहि शब्द ते प्रगट भय है सोई शब्द ग्रही लीजय साधो शब्द साधना कीजय साधो शब्द साधना कीजय शब्द वेद पुराण कहत है शब्द वेद पुराण कहत है शब्द सब ठहरावे शब्द सुर मुनि संत कहत है शब्द भेद नहीं पावे, साधो शब्द साधना कीजे, साधो शब्द साधना कीजे। शब्द सुनी सुनी भेख धरत है, शब्द कहे अनुरागी, षट दर्शन सब शब्द कहत है, षट दर्शन सब शब्द कहत है, शब्द कहे बैरागी, साधो शब्द साधना कीजे, साधो शब्द साधना कीजे। शब्द माया जग उत्पानी, शब्द केरा पसारा, कहाँ कबीर जहाँ शब्द होत है, तबन भेद है न्यारा, साधो शब्द साधना कीजे। जो ही शब्द ते प्रगट भये हैं, जो ही शब्द ते प्रगट भये हैं, सोई शब्द ग्रही लीजे, साधो शब्द साधना कीजे, साधो शब्द साधना कीजे।
Gods are pleased with the offering of flowers, and so are the human beings. On behalf of the Trust and the Lecture Committee, I would like to welcome our honorable guests with presentation of bouquet.
May I now request Ms. Darshini Pathak, trustee of the Praleen family, to offer flowers to the honorable guest, Honorable Justice Nariman, Judge, Supreme Court of India.
May I now request Ms. Saloni Shah to offer flowers to Honorable Justice Shri R. Subhash Reddy, Honorable the Chief Justice of Gujarat High Court.
May I now request Ms. Hina Rana to offer flowers to Mrs. Sanaya Nariman.
I may now request our honorable guest, Honorable Justice Rohinton Nariman, Judge, Supreme Court of India, to enlighten us on today's topic.
Chief Justice Reddy, Honorable Judges of the Gujarat High Court, Kamal Bhai, thank you for everything you said about me. I don't believe a word. Suresh Bhai, Nirupam Bhai, my dear friend Dushyant, ladies and gentlemen. Today's subject takes us back to the year 1787. As Suresh Bhai Shelat told you, these are the words of a man who was only 30 years old at the time he wrote them, Alexander Hamilton. The Federalist Papers, and these words are from paper number 78, which is a very famous paper, were basically crafted by three very great people. The youngest, Hamilton himself, who wrote 51 out of 85 of them. The second, James Madison, who was the fourth president, also called the father of the US Constitution. And the third, John Jay, who became the first Chief Justice of the United States Supreme Court. Now, what is interesting is that these papers were written in order that the state of New York, which was one of the 13 colonies, so to speak, which formed the United States of America, ratify the US Constitution after it was drafted. There were various drafts which went through, but the basic draft was the Virginia draft of James Madison, which is why he is called the father of the Constitution. And in order that New York ratify the Constitution, it required the persuasive powers of one of its youngest subjects, Hamilton, aged 30, to tell the state of New York what this new Constitution was all about. And in telling them what this Constitution was all about, he basically told them that there were three great divisions of power. And he used this expression, the least dangerous branch, because at the time, he said it was the least dangerous to the political rights of the people, being in the least capacity to annoy or disturb them. These are his exact words. And he said, when you compare the judiciary with the legislature or the executive, the legislature has the purse, dispenses the honors. The executive holds the sword. But what does the judiciary have? Only judgment. It has neither force nor will and must depend for execution of its orders on the executive, which is why he also dubbed it, the weakest branch of government. Now, as I told you, these words were spoken way back in 1787. But what he said came to pass almost immediately thereafter. There were two examples, one interestingly enough in Bombay, and the other, the US Supreme Court itself. Chronologically, the Bombay example comes first. In Bombay, a Supreme Court was set up by the East India Company in the year 1824. And that Supreme Court, unlike our Supreme Court, had very limited powers. It could only deal with the Principality of Bombay itself. It consisted at the time of a Chief Justice, West, Judge Chambers, and Judge John Peter Grant. Chambers, unfortunately, did not get on with the then governor, a man called Mountstuart Elphinstone, and also ran into members of the bar because he refused to buckle down when the bar asked him not to fix a scale of fees for them. Ultimately, he went ahead, fixed the scale of fees. The bar protested. He didn't bother about the protest and told the attorneys to come and argue before him. But all this took its toll on him, and he died at the young age of 45. That left two of them, Justice Chambers and Justice John Peter Grant. Interestingly enough, by then, the governor also changed, and one John Malcolm came, who was a 6-foot-something Scotsman, tall, ferocious, and difficult. And a petition was filed by a suitor from Pune, asking for a habeas corpus to get back his nephew, Moro, some young boy of 14, who was also in Pune. This habeas corpus writ was granted by Justice Chambers and Justice Grant. Governor Malcolm insultingly told all those who were supposed to execute the order not to execute it because it was without jurisdiction, and sent an insulting letter to the judges, which was read out in court. Incidentally, it was read out in a building which still exists. If some of you know Bombay and you've seen Lions Gate, there is a very, very old building with massive archways, which was the old Supreme Court building in which this was done. And when read out, it was in an extremely insulting tone to the judges. It spoke down to them. Justice Chambers, on this letter being read to him, felt extremely agitated and then made a very famous statement that at least in this courtroom, there is nobody above us except God and the king, and sent back the writ to be enforced. 2 weeks later, Chambers died, which left only poor Justice Grant. The writ was unceremoniously sent back, and as a result, Justice Grant locked up the Supreme Court and set sail for England. However, the matter didn't end there. What happened was that a complaint was made by the governor, mind you, not by the judge, to the board of directors in England. The board of directors referred the matter to the Privy Council. And the Privy Council, surprisingly, took the side of the governor. And then said, yes, the order was without jurisdiction. And then, ultimately, it was decided that since Grant was going to go back and sit as one of the 3 judges, the board said, we will need 2 tame elephants to be sent from here to put down this wild one. And they sent 2 other persons in order to oversee Grant. Grant asked for a transfer and went to Calcutta, where he served as a distinguished judge for about 20 years. After which he came back to Bombay, got a hero's welcome, left and unfortunately died back on his way home. So this, interestingly, was incident number 1, which illustrated the telling words of Alexander Hamilton, that unless the executive branch actually enforces your order, you are nowhere. We now go back to the United States. All this happened in the year 1828 in Bombay, incidentally. A few years later, in 1834, the US Supreme Court, consisting of its greatest Chief Justice, John Marshall, was approached by the Cherokee Indians. Now, this was a small Red Indian tribe who, by a treaty with the United States, was told that its territory in the state of Georgia was inviolable. And being inviolable, Georgia refused to give any cognizance to the treaty and passed a law saying that the Cherokee Indians were subject to Georgian law. When the Cherokee Indians went before the US Supreme Court, surprisingly, the Supreme Court turned them down on the ground of jurisdiction, saying we don't have original jurisdiction because you are a state within a state which is not recognized by us. It can only be between 2 states. When this happened, undaunted, William Wirt, who was the ex-Attorney General, decided to take up their cause and sent a white preacher called Wooster to go and preach to the Cherokee Indians and defy Georgia law, saying that under the treaty, the moment he was on Cherokee Indian land, Georgia law did not operate. Wooster did that and was arrested and put into jail, which led then to the second major judgment, again by the US Supreme Court, this time in Wooster versus the state of Georgia. That is the white preacher's name against the state of Georgia. This time, Chief Justice Marshall handed down an opinion which said, yes, the treaty is supreme law under Article 6 of the US Constitution, has to be followed not only by the center but the state as well, and that Wooster could not possibly be denied the benefit of Cherokee Indian law, which alone operated, and his arrest therefore was wrongful. Now, the president at that point of time was an obdurate general by the name of Andrew Jackson. He is famously reported to have said, Marshall has written his judgment, let him enforce it. And what happened thereafter was a little strange, because Wooster succeeded, but the Cherokee Indians got thrown out. And what happened was that it so happened that another state, South Carolina, started defying federal law within its state and said federal taxes can't be collected in our state. So Jackson then exhorted Congress, who passed what was called the Force Bill at that time, that the military could be sent in order to enforce federal law within a state. What happened was that somehow or the other, Wooster, being a white man, happened to get released. And ultimately, therefore, the Supreme Court judgment was executed. But the whole basis of the judgment was that the Cherokee Indians would not be bound by Georgia law within their territory. President Jackson used this force bill to force these very Indians out of Georgia. And what was described as a vale of tears took these poor people all the way to Oklahoma in breach of a solemn treaty made with the United States. And on the way, in a place called Little Rock in Arkansas, Chief Ross, the Indian chief's wife, died and is buried. And a mile away from where she is buried, another great drama took place, which I'll come to immediately. These two instances have shown us that at least in the early 19th century, the court was indeed a very fragile institution because the executive could with impunity disregard its orders. We now come to the famous US Civil War, which took place as a result of a decision in Dred Scott's case, which most of you people must be knowing about, which was handed down in 1857, the same year as our mutiny, by the US Supreme Court. And ultimately, Dred Scott, a black, was held not to have rights as a human being at all. He was considered property. And the court used Marbury, which was an 1803 judgment in 1857, to strike down yet another act of Congress, which was called the Missouri Compromise, which dealt with free states and slave states. And if a slave somehow got free beyond a certain meridian, he remained free. This, the court said, didn't square with the Fifth Amendment because the slave was property. He was not a human being. It struck it down. All this led to the Civil War. This led to President Lincoln being assassinated. And ultimately, the three great amendments that were passed, 13, 14, and 15, abolishing slavery and granting equal rights. Now, unfortunately, to enforce these amendments also took over a century. Because what happened in between was that you had in several cases, the civil rights cases, slaughterhouse cases, etc., whittled down the scope of the amendment to apply only to blacks first, so that it couldn't apply to other immigrants like the Chinese, for example, who lost a case. And to make it apply only against state action, which meant that private discrimination could continue. It's only the state that couldn't discriminate. Ultimately, in a judgment delivered in 1896, the first Justice Harlan dissenting in Plessy versus Ferguson, they said, we will allow Congress and we will allow the states, this is the Supreme Court said, to have separate but equal facilities so that there would be no intermingling between the two races. If you set up a school for whites, you should set up an equally good school for blacks, and so on. Now, this continued right till the 1950s after the Second World War. And for the first time, in a very famous case, Brown versus Board of Education, the Supreme Court was again faced with this separate but equal doctrine, so to speak. And the first hearing took place before a Chief Justice, Vinson, who was weak. Fortunately, the case was reheard, and he died in the process of rehearing. So that post-rehearing, it came up before one of the most remarkable Chief Justices, a man called Earl Warren. Macaulay had famously said that in the navy of Charles II, there were seamen and there were gentlemen. The gentlemen were not seamen, and the seamen were not gentlemen. Similarly, you have great judges and you have brilliant judges. Great judges are not necessarily brilliant judges, and brilliant judges are not necessarily great judges. Chief Justice Warren was a great judge, not a brilliant judge, because he had leadership ability, which is what was most required at the time of Brown. So at the second hearing in the Brown case, there were certain Southerners who were plantation owners among the judges who held out and said, no, we think Plessy versus Ferguson is correct. After all, there is equality. Why should the races mix? And it took lunch diplomacy of a very high order for Chief Justice Warren to ultimately bring to his side Justice Clark and Justice Reed. The latter stood out right till the end. So they had a second hearing, and you had a Brown 2, in which, because of Justice Reed and because of Chief Justice Warren's desire that there be a completely unanimous front for this earth-shattering decision, the second Brown case then left it to the federal district courts to desegregate, so that this would not come as a huge shock to the nation all at one time, but would take its time. And the words used were, you will desegregate with all deliberate speed, purposely vague language. Now, the process itself took a long time. But coming back to Little Rock, if you remember, in Arkansas, where the great Indian chief Ross' wife was buried, the school district there, because of the governor, a man called Forbes, refused to desegregate. The federal court, which by the Supreme Court judgment was ordered to see that desegregation took place, specifically sent out an order saying desegregate. Governor said, we will not desegregate. Fortunately, and this was the year 1957, President Eisenhower sent out the 101st Airborne Division, which division consisted essentially of blacks. Symbolically, it was very interesting because it was one of the hardest hit American divisions in the Second World War, having fought the Battle of the Bulge in late December 1944. And 1,000 troops, crack troops of this division, were sent down to enforce that district judge's order, so that by force, in Little Rock, Arkansas, desegregation took place for the year 1957. But that was not the end of the story. The next year, the district board decided to defy the Supreme Court yet again and said, ultimately you have left it to us. We will decide that we will desegregate only after 30 months, 30. So this then led to stage 2, where the celebrated case of Cooper versus Aaron was then taken up, again by Chief Justice Warren in the US Supreme Court. Again in a unanimous hard-hitting decision, it was stated that if necessary, federal troops should be called out to enforce this order. But the board had the last laugh, because the board then said, we'll take a referendum of everybody in the city. And by an overwhelming majority, the referendum decided, we'll shut down the school. So that we will defy the desegregation order, we'll have nobody, no whites, no blacks. And that obtained for the year 1958, with the Supreme Court sitting helplessly by, until finally in the year 1959, desegregation actually took place under the auspices of both the President and the Supreme Court. And slowly and steadily, the country limped forward till the Civil Rights Acts were passed by Lyndon Johnson in the 1960s, piloted, of course, by President Kennedy. Now, all this shows you that the judiciary, having to depend upon the executive for enforcement of its orders, was not just an 18th century phenomenon. It went way into the 19th century. Today it's taken for granted. And this brings me to part 2 of my talk. Now that this is taken for granted, Is the judiciary the least dangerous branch because of some problem within? The judiciary ultimately is the ultimate bulwark against the government of the time if it misbehaves, in order to support the rights of the people. In times of war, how has the judiciary fared? For this, we'll refer to a couple of First World War and Second World War decisions. We first come to the decision in Hirabayashi's case and Korematsu's case, both US Supreme Court judgments, during the course of the Second World War. All of you know that despite President Roosevelt wanting to enter the war, Congress steadfastly refused. And it took the Japanese attack on Pearl Harbor on 7th December 1941 to ultimately make Congress declare war on Japan 4 days later. The result of this declaration of war was that in February 1942, President Roosevelt, under the auspices of Congress, issued an executive order, which executive order declared the entire West Coast as a militarized zone and gave powers to the army authorities in that militarized zone to pass orders necessary to combat espionage and sabotage. And the orders passed concerned themselves with US citizens of Japanese ancestry. There were a very large number of them on the West Coast. Now, Fred Korematsu happened to be the grandson of an immigrant Japanese. So, he was a second-generation American, born in the United States. The two orders that were challenged before the Supreme Court, passed by the general, a man called Dewitt, was first an order which was a curfew order, which said that all the Japanese in the West Coast, that is persons of Japanese ancestry, you could go back 3 generations, all of them would have to stay in their homes between 8 p.m. and 6 a.m. Because, according to the general, it was in the dark hours of the night that espionage and sabotage was at its highest. This was challenged in Hirabayashi's case. And a unanimous Supreme Court said, yes, that's perfectly all right. Because after all, we are fighting a war. There is an imminent threat of invasion. I don't know where they got that from. And because there is this imminent threat, we are not persons who can now step into the shoes of Congress or the executive. They can judge best when there is a world war going on, and therefore hands off. And this curfew order was therefore upheld. But now came a very serious order, an order which was a much more serious infraction in the fundamental right of a US citizen. This order was an externment order, so that persons like Korematsu would now have to leave their homes and be put into concentration camps without any determination of whether they were disloyal, without anything. There was no charge against them, nothing. It was like an order of preventive detention. You are herded into a concentration camp. He defied the order, so he got 5 years jail, apart from the concentration camp, and took his case all the way up to the US Supreme Court. This time by a decision of 6-3. Justice Black, leading the court, otherwise a very great libertarian judge, said, look, there is an imminent threat of invasion, and used the same sort of logic as Hirabayashi, and ultimately said, we are not persons in times of war to get into all these niceties. This is a time of war, therefore, what the executive thinks best is best. But interestingly, 3 judges dissented. The first judge was Justice Roberts, the famous Justice Roberts, whose switch in time saved 9, if you remember. Because Roosevelt wanted to pack the court, because the court was striking down all his New Deal legislation. This Justice Roberts switched at the last time, and 5-4, striking down became 5-4 upholding. And here he spoke with great verve and said there's nothing like an imminent threat at all. This is pure racism. We don't recognize it, and it therefore violates the 14th Amendment and must be struck down. The second judge was an ex-Attorney General, Justice Murphy, who pretty much said the same thing. And the third dissenter was the most interesting judge of all, the great Justice Jackson, who represented the US at the Nuremberg trials, if you remember, as the special US prosecutor, sitting Supreme Court judge sent as a prosecutor. He, being the best lawyer of the three, put it on the ground that if you cannot criminalize a son for his father's activities, how can you criminalize any Japanese of ancestry which may go back 5 generations for what his father may or may not have done, that is, come here? So he would strike it down on that ground. He also said correctly that in 1944, where's the question of an imminent threat of invasion? There's none. So we find again that somehow or the other, the US Supreme Court in the time of supreme need, that is at the time that a war was going on, failed somehow or the other to protect the right of citizens who were from Japanese ancestry. Congress ultimately in 1988 undid the damage to some extent by passing a law saying that for everybody who was wrongfully so confined, they should get damages of $20,000. We now move to the UK. Was the UK any better before coming to our country? A First World War judgment in Rex versus Halliday, 1917. House of Lords was faced with something similar. This time the First World War was going on. A man called Arthur Zadig, German, who was naturalized in England in 1905, that is long before the war started, was preventively detained under a Regulation 14B, which was passed on the ground that you could detain anybody who had a hostile origin or association. Now the court, Lord Finlay speaking for the majority, said again, we are in times of war, we are in times of trouble. It is not for us to judge, it is for the executive to judge. And therefore, this kind of an order would pass muster. The dissenter, please notice there's always a dissenter, fortunately, in all these cases. Lord Shaw went way back to Magna Carta, said that in Magna Carta itself, something like this would not have passed muster. Quoted the famous 39th and 40th article, said, where is the law of the land? Where are the judgment by the peers of the law of the land? Where is the fact that justice cannot be denied, delayed, sold? It is being denied to a man who has been naturalized and now who seeks cover of our law because he's a UK citizen. Nothing has been shown to us. And the executive said, we will show you nothing to show that he was involved in any anti-national activity. So he exhorted, he went back to Magna Carta, went back to the Petition of Rights, 1628. And ultimately ended by saying, we are judges, we have to administer law, we are not politicians administering policies. So it was another hard-hitting and good dissent, but unfortunately only a dissent. The same thing happened in the Second World War. Again, the House of Lords was faced with a judgment, the famous judgment of Liversidge versus Anderson. And here again, unfortunately, the majority refused to look after Liversidge, who said he had been wrongfully detained. Not only was he wrongfully detained, he was also claiming damages for that wrongful detention and only said, give me the grounds, tell me why you have detained me. House of Lords said, no, sorry. The satisfaction of the Secretary of State is final, and it is not that we can say that his satisfaction is something subject to judicial review. If he thinks X or Y, good enough. Again, in a very hard-hitting dissent, Lord Atkins stood up And Lord Atkin's judgment has come down to us as one of the classics of legal literature. It used some very famous phrases. Amidst the clash of arms, the laws are not silent. One of another, that I do not like judges who are more executive-minded than the executive. A third, unfortunately, the Court of Appeal and my brethren seem to be affected by the subjective virus. So again, hard hitting. And finally, he quoted from Alice in Wonderland and said, ridiculed the fact that if somebody has reason to believe or somebody is to be satisfied, the Secretary of State, then he cannot think that he has reason to believe or think that he is satisfied. He said, if I have broken my leg, it doesn't mean that I think I have broken my leg. Either I have broken my leg or I haven't broken my leg. And quoted this from Alice in Wonderland. When I use a word, said Humpty Dumpty to Alice, I mean the word to be exactly. Talks back to Humpty. His answer was, it depends on which is to be master, that's all. Now with this hard-hitting, brilliant speech, at least something of the law was salvaged by a dissenting judgment. When we come to our country, we find an institution set up under a constitution which has learned from all these mistakes. So there's a very fundamental difference between the articles in our constitution and the US Constitution or the unwritten English Constitution, so to speak. Here, not only do we have Article 32, which itself is a fundamental right to enforce fundamental rights directly before the Supreme Court, but we also have a very important article, 145(3), which to the best of my knowledge is not there in any of the older constitutions, which is that this is the ultimate arbiter of the Constitution. A minimum of 5 judges will tell us what this Constitution means, and nobody else. Very important. Apart from this, the High Courts are given vast powers under Article 226. And the Supreme Court itself has a very vast appellate jurisdiction under Article 136, perhaps the vastest in the world, because it can pick up something directly, in theory at least, if not in practice, from any judgment, order, determination passed by any court or tribunal all over the country. And one other very interesting article, 142, which again I don't think exists in any other constitution, which is that as the buck now stops here before the final court, the final court is given the power to do complete justice in every cause or matter before it. You remember Justice Jackson's famous words. We are final not because we are infallible. We are infallible only because we are final. And if there were a super Supreme Court sitting above us, he said, I have no doubt that a large number of our decisions would be set aside. But the buck must stop somewhere. And when it stops somewhere, that ultimate court must be also given the power to do complete justice in the cause between the parties. Apart from that, we have one other very important article, 144, which deals directly with what Hamilton said, that every authority in this country is bound to enforce the Supreme Court's judgments or orders. Now, with these vast powers, has this court also lived up to what it is expected, at least by the founding fathers? I would say yes, in large measure. Because as an institution which is meant to look after the rights of the people, in ordinary times it has done very well. Golaknath's case, for example, 11 judges ultimately said, you Parliament cannot touch fundamental rights at all by constitutional amendment. Even though that was undone by Keshavananda Bharati's case. Keshavananda Bharati laid down something which has never been laid down anywhere else in the world, at least up till 1973. Namely, that a constitutional amendment can be struck down on substantive and not procedural grounds. And you know, of course, what the aftermath was, because you had a very strong executive at that time. So the aftermath was the second supersession. The first supersession, incidentally, took place before this, because a man called Justice Imam, unfortunately, lost his mind while on the bench. And Gajendra Gadkar was therefore made Chief Justice instead of him, which was understandable. But this time, the moment the judgment was delivered on 24th April, and Chief Justice Sikri had 1 day to go, an order came superseding 3 of the senior judges who happened to side with the majority, including Suresh Bhai Shelat's uncle, Justice J.M. Shelat, who would have then, in the ordinary succession, become next Chief Justice. Now, here also I must tell you something interesting. Originally, in the federal court, there was nothing like the senior-most puisne judge becoming Chief Justice. In fact, after Sir Maurice Guire, Justice Vardacharya, who was the next senior-most judge, was passed over, and an Englishman called Patrick Spence was brought from outside as Chief Justice. So if at all, when our Supreme Court was formed, we already had a precedent of somebody else being brought over the heads of the judges to become Chief Justice. Justice Kanya, as you know, became our first Chief Justice and would ordinarily have carried on for about 11 years. He was 54 when he was appointed. Unfortunately, he died within a year, which opened up the succession. And the moment it opened up the succession, the major problem the government of the day faced was to try and see that Justice Mahajan did not become Chief Justice. Because the then Prime Minister and this great judge had had many differences in the past, particularly when he happened to be the Prime Minister of Kashmir in 1947. So there was first a move in which the Prime Minister tried to bring Justice Chagla from Bombay over the heads of all these gentlemen. Apparently, it seems that all of them said they would resign, so that unwittingly, therefore, the executive backed off, and the seniority principle, therefore, got established. When Justice Patanjali Shastri retired and Justice Mahajan's turn came, again the same thing was tried. This time, to try and bring forward Justice B.K. Mukherjee, who was the next puisne judge. Again it failed. So that at least till the supersession, this particular principle seems now to have become part of our constitutional law. With the supersession, of course, Chief Justice was the 4th puisne judge who became Chief Justice, namely Justice A.N. Ray. Now, even though an emergency was declared here, which was like war, because like you had World War I, World War II, which were, of course, of a much greater magnitude. Here, you had an emergency declared taking away all fundamental rights. The first thing that the court was faced with was an amendment passed, the 39th Amendment, which actually put the Prime Minister and 2 other dignitaries, President and Vice President, above the law. 5 judges, including Chief Justice Ray, were unanimous in saying that it could not pass muster for various reasons. Used the Keshavananda Bharati principle and struck down the amendment. So the very first thing that they did after the emergency was declared was a very laudable thing, namely to strike down an amendment which would otherwise have subverted the entire constitution. But the second thing they did was what still sticks in my throat at least. 9 high courts had held in this country that habeas corpus writ petitions could be issued even in an emergency, even with Article 21 gone, in limited circumstances. What if under a preventive detention act like MISA, They wish to catch Mr. X and they catch Mr. Y. Can Mr. Y not come to a court and petition it saying, the warrant and the detention order both say, it is Mr. X, I am not Mr. X? Can you also not say that the detention order is procedurally bad? There are certain safeguards provided in the Act. Can you not petition a court to say that those safeguards have not been followed, therefore please release me? 9 high courts held that yes, even though Article 21 may have gone, Article 226, which gives the power to high courts to issue writs, has not gone. And the habeas corpus writ is available in these limited circumstances. Unfortunately for us, again, like the US Supreme Court, like the House of Lords, in times of trouble, in ADM Jabalpur's case, a majority of the judges left the country now. And upset these 9 high courts, stated Article 21 was the sole repository of personal liberty, and said that even in these limited situations, habeas corpus writs will not issue. It is Justice Khanna alone who stood up, which again brings us back to Chief Justice Warren. It is not necessary that a great judge be a brilliant judge. By no means could anybody say that Justice Khanna was as brilliant as the colleagues who formed the majority. But he was the man with character. He was the man who stood out. And he stood out on every score. First and foremost, he said Article 21 cannot be said to be the sole repository of liberty, and gave very good reason. 2 of which at least were that we have a UN charter now which tells us these are fundamental, these are inalienable, these are natural rights, which inhere in you because you are human. And the other was by a process of legal reasoning. Article 372 says that the common law, which was the law in British India at least, before the Constitution came into force, will continue. Under the common law, you certainly could, in the time of an emergency, petition a court, maybe on limited grounds, for a habeas corpus writ. So he said that common law has not been effaced. But ultimately, this great judge became the next super session. And he's supposed to have told his wife the day he delivered the judgment that he had lost his chief justiceship, which in fact happened. Mr. Nani Palkhiwala wrote a great article on him. And I remember his last words, which were beautiful. To the stature of such a man, that is Justice Khanna, the Chief Justiceship of India can add nothing. So we have seen that every time in times of trouble, courts all over the world somehow or the other have buckled. But every time there has been a beacon light, there has been a dissent. And fortunately for us, that dissent usually becomes law, either because it's overturned by a court or it's overturned by a constitutional amendment. Here we find that when the Janta came in, by constitutional amendment, they overruled ADM Jabalpur's case and said that under no circumstances, even in an emergency, can Article 20 and 21 be touched. So, the importance, therefore, of our Constitution, which puts paid to Alexander's great difficulties that he envisaged, is that we as a body are given the greatest power to see, number one, that the laws conform to the Constitution, and number two, that they are faithfully obeyed. I have no doubt, speaking as a lawyer, as a constitutional lawyer, I have no doubt and I have a great hope that this institution will always stand up to this great task. And equally speaking as a priest, I pray that it does. Thank you all very much.
Thank you very much, sir. We are indeed grateful to have your thought-provoking speech. I request all to rise to to honor our national anthem.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
कोई बात नहीं जमशेद भाई बात because the Bangalows are told that a grizzly is coming.
स्मेल आ जाए ना
बच्चा F
that was in good form. You know what he has brought us back as by name advocate. No, the rules if I raise a memo, let's say on Amarchand of 1 lakh, I have to pay service tax on the 5th of next month, following month, whether the bill has come or not, pay check. And if they don't give 1 lakh and give 75,000, I still have to pay on 1 lakh.
I can talk about the first court, the judgment, this, that, and make it something presentable to the world. Chalo, sir. Thank you.
Bye, sir.
Thank you.
See you.
Bye, Kamal. Thank you.
Next time.
Thank you very much. I'll call you up. I'm good to see you. Really enjoyed a lot. Great.
Bye, Rob.
All the best.
Take care. Somebody is
Of course.
Thank you, dear. Thank you.
See you. Bye.